Welcome to Mastering Cognitive Bias in Mediation, How Mental Shortcuts Impact Settlement Outcomes. I'm Belinda McCauley, Executive Director and CEO of the Beverly Hills Bar Association. I'm delighted to be here today to introduce our speaker, Ed Oster. Ed is a mediator with Judicate West, where he has handled nearly 1,000 insurance-related disputes across 36 states. He brings 38 years of prior experience as a trial attorney, as a trial attorney, focusing on insurance coverage, bad faith, and commercial litigation. He has served as a court-appointed arbitrator and judge pro tem for the Orange County Superior Court and has spoken on mediation topics for DRI and the American Conference Institute. Now, let's get started.
All right. Well, thanks very much for that introduction, Belinda. And my thanks to all of you for joining me this afternoon. I appreciate the fact that you're here to improve your skills to get to the top. Not just to get a good result in mediation or a pretty good result, but to get 100% of the best deal possible. In other words, to get everything, just like the hero of this story. A grandmother was walking with her adorable grandson along a placid seashore. Suddenly, out of nowhere, a huge wave crashed upon the shore and swept the little boy away. Well, the poor woman was hysterical in her grief. Falling to her knees, she wailed, "God, oh God, why have you done this to me? Please give me back my grandson, and I promise I will never ask you for anything ever again." Just then, out of the calm sea, another wave crashed upon the shore, and there was her grandson. Stunned, but recovering her composure, the woman looked up and said, "He was wearing a hat." And sure enough, the next wave arrived with his hat. To build upon and improve your skills to enable you to get everything there is to get, today, we're going to have a detailed conversation about cognitive bias, something that is present in every decision-making process. Then we're going to focus upon cognitive bias specifically in mediation, working with the 5 most prevalent biases in mediation and techniques for disarming them, recognizing them, using them to your advantage. So let's begin. Think about it for a moment. In your legal career, you may well be involved in dozens and perhaps even hundreds of mediations. The facts of each case are going to be different. The applicable law will change, and you will encounter different parties as well as different attorneys, judges, and jurisdictions. The one constant that impacts all of these mediations is the existence and operation of cognitive biases. If you can master only one skill in mediation, utilizing cognitive biases to your benefit would be an excellent choice. The truth of the matter is that during almost all mediations, nobody is thinking about the concept of cognitive bias except maybe the mediator. If you somehow had a printout of the thought stream of all the participants in a mediation and did a word search of the tens of thousands of words that went through all their minds, I guarantee you the cognitive bias wouldn't come up. And yet it's there all the time. We don't know about it. We don't think about it because we're immersed in it. It's kind of like the 2 young fish swimming in the water when an older fish swims by and calls out, "How's the water, boys?" The 2 fish look at each other with a blank stare and swim on. Finally, one of them says to the other, "What's water?" Well, to paraphrase our young fish friends, what's cognitive bias? So now let's talk about the nature, origin, and operation of cognitive biases. Simply put, cognitive bias is a subconscious error in the human thinking process that influences decision-making. For example, confirmation bias, the tendency to only consider information that aligns with our preconceived ideas, limits information we consider when making decisions. Have you ever found yourself, for example, only reading news stories that support what you already think? Researchers group cognitive biases in negotiations into 3 buckets: distortions about how we see ourselves, distortions about how we see others, and distortions of the subject matter, usually favoring ourselves. Because distortions caused by cognitive biases operate on everyone in negotiations, it is essential for you to perceive the impacts not only on your opponent, but also on yourself. To better comprehend and work with cognitive biases, it is helpful to understand the 2 systems the human brain simultaneously uses to process information in decision-making, and then one additional term, heuristics. Every time I think of the word heuristics, by the way, Heuristics, I think of the extreme negative reaction that my wife has to it, and I don't know why. But she says, heuristics, it's such a turnoff. Why are you doing this? Heuristics. Well, as you'll find out, the term heuristics is just a fancy psychologist way of describing what the rest of the world would refer to as a mental shortcut. But it's deeply involved in cognitive biases, so we're going to go into it. Two systems of decision-making that are operating all the time in our brains. In the 1970s, psychologists Amos Tversky and Daniel Kahneman conducted research in behavioral economics that ended up earning them the Nobel Prize in economics. Their experiments resulted in the development of the theory of two systems of decision-making processes simultaneously at work in human beings during the thought process at all times. Kahneman authored an award-winning book on the topic in 2011, Thinking, Fast and Slow, in which he expanded upon the two systems always at work in decision-making. System one, thinking fast, is the intuitive, faster thought process way of making decisions. It automatically and rapidly processes data using unconscious innate heuristics to reach a decision instantly. As I mentioned earlier, a heuristic is a mental shortcut that the brain automatically uses to quickly make decisions based upon little information with minimal cognitive effort. For example, you see a person in a dark alley with their face concealed and intuitively decide to walk past just a bit faster. These mental shortcuts, heuristics, are beneficial for making the millions of decisions people make in daily life that don't really require deep thinking. Remember, the human body is hardwired to protect itself and to conserve resources, especially energy. Extensive use of heuristics is the primary means of conserving mental energy. To give you an idea of how important this is, it has been postulated that without heuristics, the human brain would consume so much energy and generate so much heat in the process in making trivial everyday decisions in our daily lives that our brains would literally melt by around 10 o'clock in the morning. System two, thinking slow, is the more idealized way of decision-making that involves critical and analytical thinking, but it's also much slower and requires a much greater expenditure of mental energy. It uses conscious thought processes to solve complex problems by analyzing, weighing, judging new evidence, solutions, and alternatives. All of us have been involved in that, and that's why so many times at the end of the day, even though we're sitting at a desk pushing paper, analyzing problems, we're mentally exhausted. Physically, I should say, and mentally exhausted. System one, fast thinking, using heuristics that warned our ancestors of danger, enabled them to survive because those who could not instantly distinguish between danger and dinner were removed from the gene pool. Heuristics saves time by instantly drawing upon information that is already stored in the brain, rather than evaluating each decision as new and different. Unfortunately, this also results in creating cognitive biases, which cause us to draw incorrect conclusions about new information and new circumstances, or in our case, new problems, new situations that have to be addressed. Cognitive biases influence our decision-making processes by drawing us to particular conclusions. We are predisposed to these conclusions by information gathered and stored in our brains. Our decisions are subconsciously based upon information our brain selects that meets our preconceived ideas, prior decisions on a similar issue, self-interest, and emotional distractions, regardless of the existence of any new or conflicting ideas and information. Too often, the end result is poorly informed and poorly reasoned decisions. And that's why we call it a subconscious error in the human decision-making process. Let's spend a little time now focusing on cognitive biases in mediation. There are hundreds of cognitive biases that impact analytical, rational decision-making. Among the most common in mediation are confirmation bias, reactive devaluation, anchoring bias, frequency bias, and optimistic overconfidence bias. I'm going to repeat those again because these are the 5 that you are most likely to encounter. Confirmation bias, reactive devaluation bias, anchoring bias, frequency bias, and optimistic overconfidence bias. Let's start with confirmation bias, something that most of us probably have a lot of experience with and you recognize readily. Confirmation bias causes us to seek out or consider only that information which supports our preconceived desires or conclusions. In common terms, we cherry pick instead of considering all of the information available from all sources. It's also, by the way, related to the idea of cognitive dissonance, the psychological discomfort that results from having to confront data or facts or situations that conflict with our pre-existing viewpoint. We shy away from it, in other words. There are multiple reasons why we use confirmation bias when making decisions. It's easier and faster than carefully processing all of the information at hand. It relies upon information pre-stored in our brains, saving time and energy. And it protects our self-esteem when our preconceived ideas are validated. Now let's talk about anchoring bias. And this happens in mediation all the time. Oftentimes, parties are heavily influenced by expectations formed during the very beginning of a mediation. And the message here is that opening numbers are important. Anchoring bias operates to influence parties throughout the mediation based upon earlier numbers that have been initially put out, regardless of their merit or realism. It arises in mediation when the opening or anchoring offer is the starting point for negotiations. And let me stop here and make a note about this. We're talking about mediations, which for the most part are in civil litigated matters and involve an exchange of money one way or another. But many times there are mediations that involve more than just money. And what you can do is substitute those other commodities that are exchanged or bargained for or bargained over during the course of the mediation for money. And the outcome, the result, the application is the same with all of the biases that we're going to discuss. But to return to anchoring bias arises because of our need for a starting point in our decision-making, as well as the typical convention of demand and offer in negotiations. The initial anchoring number can have a very substantial impact on the outcome of mediations, even when the anchoring number is inaccurate or viewed by the recipient as extreme. It operates subconsciously. Next up, reactive devaluation bias. A good way to think of this is it can't be right if it came from them. The generally hostile environment of litigation fosters reactive devaluation, discounting an opponent's information or argument or position simply because it came from the opponent. The unspoken premise here is that the opponent is inherently manipulative and untrustworthy. Hence, reactions like, that can't be right because it came from them, or concerning a proposed solution, it's a trick if they offered it. Interestingly, a long time ago, as a matter of fact, a Cold War experiment by social psychologists Lee Ross and Constance Stillinger, described in their 1988 book, Psychological Barriers to Conflict Resolution, quantified the magnitude of this reactive devaluation bias. Here's the setup. The leader of the Soviet Union, Mikhail Gorbachev, made a proposal to reduce nuclear warheads by 1/2, followed by further reductions over time. Psychologists Ross and Stillinger took turns with control groups and subjects, interviewees, attributing the process to the US President Ronald Reagan on the one hand, and then alternatively to Mikhail Gorbachev. The surprise was not that the individual groups reacted differently to the same proposal, depending upon its source. In other words, whether it came from the US president or whether it came from the Russian. But the wide degree of difference. When attributed to Ronald Reagan, 90% of the group reacted favorably. That favorable reaction dropped by over half to 44% when attributed to the Soviet leader. Frequency bias. Frequency bias is at work when something you recently learned or become aware of appears to be happening more frequently than it actually is. In psychology circles, it's also known as the Baader-Meinhof phenomenon, named after the German terrorist group of the 1970s. I suspect that there are a few of you out there who may be familiar with that, and you may recall it got a lot of press and a lot of media attention, even though it was a very small terrorist group, a terrorist cell, but it got outsized attention and importance because of the operation of frequency bias. Frequency bias occurs because your brain becomes more attuned to noticing things that you've just learned about, leading you to perceive them as being more common or frequent or important in your environment. In reality, the frequency of occurrence remains unchanged. It's just that your perception has changed because of the influence of your new knowledge. For example, when people hear about a string of robberies or vandalism in their community, they are more likely to believe that there is a national crime wave occurring. I remember actually the first time that I encountered this phenomena when I bought for the first time in my life as a young adult, a new car, not a used car or a car that I had to rebuild in order to drive. And it was blue. It was a blue Volkswagen. All of a sudden, I was seeing blue Volkswagens everywhere. And I never realized how many blue Volkswagens there were on the road until I had one sitting in my own garage. Another example of the frequency bias that plays out at mediation is where plaintiffs make repeated reference to high-dollar jury verdicts, even if it's not the same subject matter that you may be talking about in the litigation, something completely different, or regardless of the location or the jurisdiction. They like to talk about high-dollar jury verdicts. Why? In order to foster a negotiating environment favorable to them. Actually, it's a technique that works. Then we come lastly to the optimism overconfidence bias. And again, you've encountered this, you just didn't have the name for it. The optimism element of this bias helps us to believe that most things will work out and we can look forward to a good outcome. Optimism is generally a good thing, motivating us to create a better life and a better future. At the same time, optimism can actually impair our ability to see a legal dispute accurately by overestimating strengths and underestimating weaknesses. The overconfidence aspect of this bias occurs in litigation when one side believes its legal skills are primarily the reason for or primarily account for past favorable outcomes they may have experienced, instead of the fact that they were just lucky enough to have good facts or good law. This also leads to overestimating chances of prevailing at trial and typically downplaying success for the opposition. Now, I know what you're saying to yourself right now. Why is he talking about overconfidence in your opponent? That you have never, ever encountered an overconfident opponent. Well, just in case you ever do, hear me out. The combination of optimism and overconfidence can be fatal to mediated outcomes. Many scholars and scientists who have studied this actually believe that optimism overconfidence bias is the major cause for the biggest breakdowns in the decision-making process leading to failure. It is even more of a factor when it turns out that attorneys know even less about their cases, which then has the impact resulting in even more extreme settlement positions based upon an unrealistic view of trial outcomes. In doing just a little bit of extra homework for today's conversation, I came across something referred to as the G.I. Joe fallacy. And the G.I. Joe fallacy is this. It's a mistake to believe that simply knowing about a bias is enough to overcome it. You actually have to do something to overcome it. And this is true whether you're talking about a bias that exists in your opposition or a bias that is plaguing you. And so now let's move our conversation into talking about solutions. Working with cognitive biases in mediation. Remember that the nature of cognitive biases is that they arise out of system one thinking, fast, intuitive, automatic, with little information and minimal consumption of effort and energy. The way to counteract cognitive biases is to slow things down and employ system two thinking, deliberate, conscious processes that solve complex problems by analyzing, weighing, and judging all of the evidence. Mediation gives you the time and space to do this. And that really is one of the outstanding aspects of mediation. It really does give you an opportunity to slow the process down and to give it the time and attention and effort that it really deserves. For example, when you suspect that your opponent is suffering from confirmation bias, through the medium of the mediator, inquire whether all of the evidence is being considered regardless of its source or who it might favor, and if it has been objectively evaluated. You will likely need to supply the missing evidence that is not being considered and articulate its objective impact. Open-ended questions you can formulate for the mediator work very well to that end. And remember that cognitive bias is not selective. It operates on everyone. This means that while investigating cognitive bias impacting your opposition and what you can do to overcome any biases you detect, you should also conduct the same analysis on yourself. So how do you go about doing that? Well, beginning with yourself, use the 5 cognitive biases discussed previously, the 5 that I've outlined, and use this as a checklist or a grid and run your positions and valuations through them. Are you sure that you are not unwittingly employing unwarranted thinking shortcuts? Are your positions and valuations the product of system 2 thinking? If your answer to either question is anything other than an unqualified yes, you probably have some distortions about how you see yourself, how you see your opponent, and or how you see the subject matter. If you detect the presence of cognitive bias in yourself, engage in your own system 2 process. Now, do the same thing with the positions and valuations of your opponent. Because, and let's get real for a moment, it's your opponent who is the real problem, right? Okay, so if you detect the presence of cognitive bias in your opponent, and it's highly likely that you will, what do? Well, you could try a baseball bat, or you could try brass knuckles, but that doesn't work at all when we're in a Zoom context as we are right now. And frankly, that's about 90% of the mediations in civil litigated cases these days. But joking aside, these really are serious concerns, and there are real solutions. But I implore you again, remember the G.I. Joe fallacy. It is a mistake to believe that simply knowing about a bias is enough to overcome it. It isn't. You actually have to do something. So here are a few tested suggestions for addressing specific biases you perceive to be affecting your opponent. Let's start with the first one, confirmation bias. In addition to bringing the slower system 2 thinking into play through the mediator and through open-ended questions, try to ascertain what information is not being considered and focus on that. And again, through the mediator, bring in new information from objective sources. Are there comparable verdicts or analogous situations to draw upon? And here I want to make a pitch for a little bit of pre-mediation preparation, because it's almost a certainty that there is going to be confirmation bias rampant in the mediation, in the other room, and very likely, honestly, in your own room as well. So you might consider, before the mediation even begins, doing a little research and coming up with the type of information that you think can help counter this and that you can supply to the mediator, not just the kinds of things that you would put in an advocacy brief or a mediation brief, but things that may come up in the moment. Now, I know that during most mediations, it's wonderful. You've got downtime, we've got the internet, and you can do all kinds of Googling, ChatGPT, and so forth to find information. That didn't exist 10 or 15 years ago. The internet was there, but AI wasn't really robust then as it is becoming today. Nonetheless, do a little preparation in advance. You'll not only advance your own cause, but very likely you're going to impress your client as well about how seriously and thoughtfully you prepared for the mediation. You make it look easy, and of course, that's a real good thing to exhibit all the time. Okay, let's consider another one now, frequency bias. This is a circumstance where you encounter something and the other side keeps bringing it up and bringing it up, and all of a sudden you're worried about it happening all the time, everywhere, including in your case. Well, be prepared to distinguish your case from the verdicts or other information that you think it's likely that your opposition will be providing. And here it's important to remember to check the ultimate disposition on appeal or the post-trial history, post-trial motions of any verdict that is being cited. We all have experience with the fact that you can see a big splashy verdict that appears in the newspapers, and then 2 or 3 years later, not on page 1, but on page 16, there's a small little paragraph about it being overturned on appeal or reduced or remitted or something like that. Even in a situation where your opponent does not present isolated occurrences to argue for a trend that might be worrisome for you, you should nonetheless consider coming to the mediation with your own recent data or examples for the very reason already mentioned. You want to create the negotiating atmosphere and the frame of mind that you want during the course of the mediation. Good to have this information in your saddlebags. Okay, let's talk now about anchoring bias. This is another one that I mentioned, I think is present in just about every single mediation. If you suspect in advance, if you suspect that your opponent will present an unworkable, outrageous demand, consider being the first one to set out a number and explaining its basis. You can not only help create a reasonable framework for negotiations, you also create a good first impression. If you're going to do this, by the way, and you're on the defense, I suggest that you thoroughly discuss this with your client in advance. And if the response that you get is still an outrageous demand, all is not lost. You can simply make a very, very small move the second time around. If your opponent is going to put out the first number and you know that it is going to be absurd, plan your response now. One of the things that you can do is to refuse to participate until the other side comes up with a reasonable number. But truthfully, that rarely works. Consider instead coming back with your own reasonable number or what appears to be reasonable under the circumstances and explain why it is what it is. And if there is no good response from the other side in its next move, then you can continue with a much, much smaller move the second time around. In this regard, I think it's very important for us all to remember, I mean, it really is worth recalling that in most cases, no matter how far apart the parties are, real bargaining in interest cannot begin until both sides are at a reasonable bargaining position, and typically this means dollar amount, for the case that you are all mediating. And so it's actually to your interest for the other side to get to a reasonable point and for you to be at a reasonable point as well, because as we've just been discussing, only then can the real negotiation begin in earnest. Then there is reactive devaluation bias. And this is kind of a tough one, but here is where you really need the help of your mediator. Because the truth of the matter is, trying to convince your adversary during the course of a mediation that you are not inherently manipulative or untrustworthy, if that is their view, is a big hill to climb. So the quick fix here is to have the mediator present your argument in a neutral fashion, or your suggestion or offer as coming from the mediator in exploratory fashion. And in this regard, I want to stop for a moment and really stick a pin in this, because I think we all have experience with the desirability of having something come from the mediator instead of a party during the course of a negotiation. I know my own practice is to, depending upon the room that I'm in, saying, well, they argue this, or their position in response to your argument is such as it. Sometimes that comes from the other party, sometimes it doesn't. But it's very, very important for them to have all this information. One of the things that I think is very important, the service that the mediator can provide, and something that you should insist upon with the mediator, is for the mediator to help both sides explore and know not only what their strengths are, but what their weaknesses are. And this brings into several of the biases that we've talked about already today. But the overall point here that I want to make is you've hired a mediator, and hopefully a very good mediator who is well suited to your purposes. And you ought to get the most out of that mediator. And you'll find that mediators are very compliant in this regard. They want to help you in every way they can. So you can ask a lot of questions of the mediator, not only about the other side or presenting something to the other side, but you can ask about your own position as well. Be careful, of course, because the mediator is not going to want to alienate anybody, and the mediator is there to facilitate an agreement amongst the parties. But I really think that that direct dialogue with the mediator is something that is missing in a lot of mediations and that you ought to take advantage of. And we'll talk about that a little bit more later on. Okay, of the 5 primary biases that we've been working with today, the last one is the optimism overconfidence bias. An antidote for you to consider for your opponent's unhelpful optimism is a very strong dose of pessimism in the form of realistic projection. Actively discuss what all of the potential outcomes are. And again, you need to work with your mediator in this regard. All kinds of things can happen during the course of a trial and litigation process, and all of those things ought to be potentially considered. There's no guarantee whatsoever that the one party is going to have its position that it's relying on heavily be the prevailing position at time of trial. And when pressed, the truth of the matter is that parties and attorneys admit that there are no guarantees. And while good cases should win, they don't always win. Even very good or very, very good cases don't always win. And it's important that your opponent, and parenthetically you as well, it's really important for both of you to consider the whole gamut, the whole range of possibilities. But right now we're talking about your opponent having really unhelpful optimism, and that needs to be put in the proper context. And you can do it by setting out positions or possibilities and work through the mediator in getting this done. On the other hand, recall that this is called the optimism overconfidence bias. Now I want to talk about the overconfidence part. For opponents suffering from overconfidence in their own legal ability as the reason for their prior success, instead of being fortunate enough to have very good facts and or very good law, it's a mistake to attack their abilities. Do not do it, however much it might be justified, warranted, or you just really want to do it. Instead, hold back, pour over the facts and the story that the facts tell, keeping the focus there. Making an ad hominem attack against your opponent is not the road to success. Keep the focus on the facts, and many times this will involve bringing in facts of which your overconfident opponent was not aware, as we discussed a little bit earlier. Beyond the world of mediation, acquiring expertise in recognizing and working with cognitive bias offers additional benefits. Just as cognitive bias is not selective in terms of who it influences, its impact on the decision-making process is not limited to mediation or to business pursuits. It is at work in every situation where decision-making is occurring. Becoming better at meeting cognitive bias challenges in your professional life, honestly, will likely do the same for your personal life. Now, I want to pause here for just a moment because I have some additional things that I'd like to go over with you, but I want, because I'm not the most adept tech person, I want to stop and check the questions to see where we are at, and if I can appropriately open this up, I hope, to get to the questions. All right. So the questions that are appearing so far have to do primarily with the program materials. If there are any questions that any of you would like to pose, now's your opportunity. Please feel free. And I will come back to this later before we are concluded for today. So with some of the time remaining, in brief summary, what we have, let me just kind of round things up for a moment. You start with the idea that constantly, every time there is a decision to be made, the human brain operates on two parallel tracks. There's the system one, fast thinking, intuitive process that considers little and moves very quickly, relies upon information already stored in the brain. Great for everyday trivial decisions that you don't have to redecide over and over again. Then there is the system two thinking, which is much more deliberative, much more analytical. It's conscious, it considers all of the information, and in the process consumes more time and, of course, more energy. Both of these are going on simultaneously at any given time. And with respect to the operation on and how cognitive biases arise, you'll recall that little word for mental shortcuts, heuristics. And the idea is that what the brain automatically does without us even considering it, kind of subconsciously, it goes ahead and makes a mental shortcut and doesn't necessarily consider all of the new information or the new situation you're in, but your brain automatically recalls similar and other circumstances and relies very heavily on that to make an instantaneous decision in the moment. And the problem is, of course, that overlooks a number of things that can lead to the various biases that we discussed. The five most important being, the most prevalent being the confirmation bias, frequency bias, anchoring bias, reactive devaluation bias, and finally, the optimism and overconfidence bias. And I want to suggest to you that when you just make a little list of these, and I think you've got an outline. I tried to keep it very short, a 2-page outline that you can even just bring with you to a mediation. And during the course of the mediation, go through that and see if there's anything that can help you in the mediation that day. But really, as I've said before, I think you ought to try to engage in this process well before the mediation ever begins. And in some circumstances, particularly when you're talking about making a preemptive opening offer, if you're on the defense side of things, knowing typically that the opening demand comes from a plaintiff, you might want to discuss that. You really should discuss that with your client in advance. And even if you decide not to, I suggest to you that you very likely get a few brownie points from your client for even thinking of the idea in the first place and bringing it up. So with the time remaining here, I want to turn to an additional topic that I think is really vital for excellence in mediation. And let me set it up with this brief story. A young woman brought her boyfriend home to meet her parents. After dinner, the father invited the young man to his study for a drink and to talk. "So, what are your plans?" the father asked him. "Well, plans," the young man said. "I plan to marry her," he answered. "Oh," the father said. "Well, what do you currently do?" He knew he was a student. The young man says, "I'm a student." "A student. Well, how are you going to buy her a ring?" "I will study," the young man replied, "and as it says in the Bible, God will provide." "Well, how will you keep a roof over my daughter's head?" the father asked. "God will provide," the young man replied. "And children?" asked the father. "How will you support your children?" "Don't worry, sir. God will provide." Well, you know where this is going. At every question, the young man insisted God will provide. Later on, the mother asked the father, "Well, how did it go, honey?" "Well, he has no job and no plans," the father answered. "But the good news is he thinks I'm God." Now, none of you has any illusion about mediators being God, but the point remains that mediators can't do it all alone. You need to help them, and you definitely help yourself by helping the mediator. This is a question I get a lot, honestly. I think by better practitioners. What can I do to help you help me? There are 4 things that readily come to mind. One of the first things you can do is come prepared to the mediation. And I mentioned this a little bit earlier. And by this, I mean have a plan in advance to deal with an outrageous demand or offer from your opponent. It's almost certainly going to happen in most of the mediations that you attend. Not all, I hope, but it will happen. And remembering the operation of the anchoring bias. This is what you're trying to overcome. So do some research in advance, do some planning in advance of how you are going to counter the outrageous demand or offer. And I gave a few suggestions of positions that you might take. Remember also the frequency bias. Somebody bringing up verdicts or occurrences or front page articles that they want to have an outsized influence on during the mediation. Do your own research in advance so that you can provide information to the mediator, during the mediation to employ anti-frequency bias techniques. And this is information about other verdicts or distinctions between the cases they're going to play up and yours, or simply just cases that you want to discuss. And remember that a verdict, while splashy and gets the front page news, is not a final disposition of the case. Find out what happened on appeal. If it went to appeal, find out what happened to the post-trial motions. There's another bias that we talked about a lot. For reactive devaluation, this is it can't be right if it came from them, it's a trick. Use the mediator to present your position as though it was coming from the mediator. And I want to stress again, although I know I said it earlier, I think that really there ought to be a constant dialogue between you and the mediator. Ask questions of the mediator. You can suggest that the mediator ask questions of the other side. This will help open things up and take things beyond the immediate focus, the immediate points that your opponent is relying on or wants to hammer on. Generally, you'll do better if the lens is opened up and you have a broader playing field. Next on the list of helping the mediator help you is achieving clarity in communication. And please remember this cardinal principle. All moves in mediation are messages. And that's so important, I'm going to repeat it. All moves in mediation are messages. Now, typically in most mediations, you are going back and forth with just dollar numbers. It might be a demand, it might be an offer. At some point, you might get into ranges, you might get into brackets and so forth. But you are using dollars to express what you really think about the case, not only your opinion, but the other side's. And the dollars and what you mean by it are also helping you to get to that place where both parties have to be in order for you to have a successful mediation that results in a settlement. Both sides have to be at a reasonable point. So you want to indicate through your moves flexibility or what you are willing to do. You want to encourage good moves and discourage bad moves and so forth. But everything that you do, even though expressed through numbers, is a message. And here's the key point. You want to be sure that the message that you convey is understood by the other side, whether it's a bracket or a number or something else. So for example, when you are giving a new number, you can tell the mediator that the mediator can tell the other side why you moved the way that you did. Go ahead, put it in an envelope, remove all doubt, give it context. And the same thing applies in reverse. If you're unclear about what is meant by one of your opponent's moves, ask the mediator what he or she thinks it means, or ask the mediator otherwise to find out. And you can do this even before you respond. You can have communication with the other room, not just through your messages and moves, but you can have that communication through the mediator. And most mediators are very adept at avoiding any of the biases that we've talked about today in their own dealings. They don't have a dog in the hunt. They're not in the fight, and so they have the opportunity to be neutral and stay above it and look at the whole playing field. And after all, that's what you're hiring a mediator for, at least in part. But the important thing here and the key takeaway is, however you accomplish it, make sure that your message is understood. It's not my story, but I remember being told about a circumstance years and years ago that involved the Dodger the Dodger legend, Sandy Koufax. And it was actually not about Sandy Koufax, but about an autographed baseball that he had autographed. And this, as you can imagine, was a very valuable baseball. And the circumstances that there was a young boy, really, actually, I think about 8 or 9 years old, who came into his father's study one Saturday morning and said, "Hey, Dad, let's play catch. Here, I got the gloves and I've got a ball." And what the young boy had done is taken this Sandy Koufax autographed baseball and was going to use it to play catch. Obviously, he had no idea of the value of it. And the father was just shocked, and he said, "No, no, 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 no. We can't use this ball. We can't use this one. It has writing on it here. See, do you see this? It has this writing on it. We can't use this baseball. So go and put it back where you got it." Well, 5, 10 minutes later, the young man comes back and says, "Hey, Dad, we can play catch now." And then Dad says, "What?" He said, "Look, here's the ball. I erased all the writing on it." The boy understood what the father said, but he didn't really get the message of what the father was saying. It wasn't just that the ball had writing on it, of course, that it was a very, very special and very valuable baseball. And I tell you this story in the hopes that it will just jog your memory at some point. You'll remember the Sandy Koufax autographed baseball when you are thinking about the messages that you were shooting back and forth during the mediation. Third, you can help the mediator help you by overcoming your own cognitive biases. We talked about this earlier, but there's a few additional points that I want to emphasize. Use the 5 biases we discussed today as a grid to see if you are having one of these biases work on you and interfering with your judgment and decision-making. Let me give you an example of this. Occasionally it happens in disability cases, disability insurance policies, although it's not limited to those kinds of cases, that there is a feeling that the plaintiff is a fraud. They're not really disabled, but they're asking for all this money regardless. And typically there are all kinds of cases where this occurs, in personal injury and otherwise. And I can tell you from personal experience and what I've witnessed dozens and dozens of times, it's really hard for attorneys, and most importantly, their insurance company clients, to pay money, much less pay a lot of money, to somebody that they feel in their bones is a fraud. You can reverse the situation here, but the point overall, it's just very, very hard for them to do that. But you have to overcome those feelings of, in my bones, I think that somebody is a fraud or they're wrong, or that this is a very bad defendant. And they did this intentionally and wrongfully, and I'm the one who is suffering as a result if you're a plaintiff or if you're a plaintiff's attorneys. Those gut feelings and those emotions often have way too much influence in mediation. Because the truth of the matter is, you've really got to overcome them, because what matters is not how you feel or how your client feels. It's really what the decision maker thinks. The trier of fact may not share your gut feelings, and especially if the decision maker is a judge. The judge, and even more especially a federal judge, certainly does not care about how you feel or what your gut instincts are. The judge may even think that there's some exaggeration on the part of this disability plaintiff I was talking about, or some potentially bad conduct by a defendant, but they might ignore it. Honestly, when the judge is the decision maker, especially a federal judge, they can do whatever they want. And that's really true in the case of federal judges. And in this regard, I'm reminded of a story that I was told many years ago when I was a brand new lawyer. In fact, it was the ride home from getting sworn into federal court in the Central District. And it's a story told to me by one of the people who was present there about the psychiatrist who died and wanted to get into heaven, knocking on the pearly gates. St. Peter called out, "Who are you? What do you do?" And the reply came, "I'm a psychiatrist." Whereupon St. Peter said, "Come on in." And as he was giving the psychiatrist a tour, St. Peter said, you know, we can really use a shrink around here. The psychiatrist said, no, really? Here in heaven? How can that be? St. Peter whispered to him, it's the boss. He thinks he's a federal judge. Please remember the point. Many times it's very hard for you to overcome emotions and gut instincts that you have, but you have to think outside of yourself. You have to overcome cognitive biases that are otherwise impairing your decision-making process and your judgment so that you make the best decision possible and can advise your clients accordingly. Finally, great mediation practice is to consciously cultivate a relationship of trust with your mediator, as this will open all kinds of doors for you. It's almost impossible to overstate the importance of this. You absolutely want a mediator who has your back vis-a-vis your own client and when the mediator is in the other room. A mediator who trusts you to be honest is going to be a much better advocate for your position. Like everyone else, mediators find that when they trust someone and can rely on their word, it is such a welcome breath of fresh air that they naturally gravitate towards that person or their position most of the time without even knowing. Now, there are many ways to put deposits in the trust account, but in things big and in things big and small, it boils down to saying what you mean and doing what you say you will do. It's that simple. It's been said that parties make the settlement, and I suppose that that's mostly true. More often than not, though, the heroes that I see in mediation are the attorneys who act on behalf of their clients, like the grandmother who was strolling with her grandson along the seashore who wanted it all. If you come to the mediation well aware of the operation of cognitive biases and their antidotes, you do your pre-mediation preparation, and during the course of the mediation, use the techniques that we've discussed today, you will be fully engaged like she was. And if there is a settlement to be had, you will get more than a settlement. You will get the best deal possible. Thank you all for your attention. What I'd like to do right now is to briefly check to see what kind of questions we have, if any, that might be addressed. And if you'll give me just a brief moment and an opportunity to do that. All right, we have a handful here. The first question has to do with dealing with an opponent who is launching ad hominem, that is to say, personal attacks against you with the court. And this is not taking place necessarily in the context of mediation, I gather. It's something that can happen just about any time. I don't know that there is a particular technique, about this that has to do necessarily with cognitive bias, but I will share this experience. Most of the time when there's a personal attack, and the judges don't want to see this. They want very much to see opponents disagree and strenuously disagree, even very aggressively disagree with one another, but still treat each other as professionals. They don't like to see personal attacks taking place. And my suggestion would be to take advantage of that orientation bias, if you want to call it that, but that orientation of the court, and try to rise above the situation. And you can say something like, however much it might be appropriate to respond to that attack, Your Honor, or whatever, instead, I will concentrate on the reason why we are here, and then go ahead and talk about the specific legal issue or process that you're involved in. But, many times when there's a personal ad hominem attack like that, it's kind of bait that the other side is putting out there and hoping that you will pick up because there's some larger issue or subject matter that perhaps they want to distract against. Let me take a look at another question here. This is a pretty good question here. This one says, it's a lot to juggle and to move against your biases in the moment. how can you practice it? You have in mediation substantial downtime when the mediator is out of the room in the other room. And that is the time to do it. Mediation really is unique in that it gives you the time and space to slow things down. Rarely are you going to have a mediator who's going to come in and say, I've got a number for the other side. You've got 30 seconds to give me a response. Nobody's going to do that. So you have the opportunity, I think, virtually just about every time, even with just these 5 that I've mentioned to you, to say, is this in operation? Is this in effect? And so forth. And it is a lot, but what I can tell you is this: if you try it a handful of times and even put it down on 1 or 2 3x5 cards and have you with it during the mediation, it gets easier and easier each time to do it. It sounds like a lot at first, but you'll get used to it. And hopefully some of the stories that I told today will help you remember these things. Let me take a look briefly at the other questions that we have. Okay, here is the question. As a mediator, what do you do to counter these, referring to the 5 biases, when you see them in play? Both sides overconfident, reactive, practicing blatant confirmation and frequency bias. The number 1 technique is to ask genuine, neutral questions. And we all are aware of the practice of somebody asking a question which isn't really a question. It's more of a statement, or there's some other approbation that they are engaging in. So sometimes when you're walking in an area and somebody comes up to you and say, "Can I help you?" They're not really there to help you. They don't want you to be there. That's a statement. The statement is, "I don't want you to be here." During the course of a mediation, I try, in circumstances like this, and even when these circumstances aren't present, to ask genuine questions in a non-threatening way, where I'm not trying to push them into a particular direction, but they're wide open questions that are genuine questions, like, why do you think that they feel that way? What do you think would motivate them? What do you think they are basing that on? And is that accurate? What can we do? Real big open-ended. What can we do to counter this thought process? In my library, there's at least 3 books that are all about asking questions in mediations, and most good manuals refer to it. So as long as it's not a question that is really a statement, particularly a critical statement in disguise, I think open-ended, genuine questions are one of the very best ways to bring that out and get a discussion going. Say, well, if they really think that, well, why do they think that? And what are they basing that on? Or do you really think this? What might you do? What are you basing it on? Those are the kind of things that readily come to mind. That brings us to a close for today. Again, I want to thank all of you for taking the time to be with me. This is a topic that I love. I think it's fascinating, and I think that it's a real good shortcut for improving your mediation outcomes substantially. To each of you, I wish you all the very best, and thanks very much for your time.